Warren Cassell.
Yes.
Your Lordships, I appear for the appellant, together with my learned friend Miss Pinto, and Mr. Horace Sullivan sits to my left, the Director of Public Prosecutions of Montserrat. The respondent is represented by Mr. Thomas Rowe, King's Counsel, and assisted by my learned friend Dr. David Dorset. My Lords, the matter is listed today for hearing an appeal against a decision of the Eastern Caribbean Court of Appeal, the application having been made for this appeal on the 24th of April of 2025, and permission being granted on the 10th of December of last year. The respondent has also sought permission on further appeal points, and permission has been granted for him to address those. Lords, can I address the question of how we approach today, just so there's a misunderstanding?
Because you appear to have agreed a quite complicated timetable.
I'm sorry about that.
I understand why, I think. I can guess why, let me put it that way.
I try and simplify it, and of course all the timings are entirely flexible, dependent on matters that the court considers it doesn't need to hear concerning because of the extent of written submissions. But the proposal agreed in summary is this, that I essentially advanced the argument upon which we were granted permission in terms of the Court of Appeal's decision and the rationale, that my learned friend then responds.
So that's the jury bundle point, really, is it?
Yes.
Yeah.
So just really the jury bundle point, my Lord, precisely that. My Lord, the argument at that stage, or this stage, is confined to that.
Yes.
My learned friend then responds on that point, and we factored in the potential for a reply as well. Of course, all these timings, we don't know, will be entirely guided by the court. And thereafter, the proposal was to consider the respondent's various points, which appear in the statements of facts and information, as you would have seen, at paragraphs 14.1 to 9.
Yes. Well, and therefore one could put against this timetable jury bundle points for the first three stages, which takes us up to 12:15, and then all the other points in relation to which the respondent's going to start thereafter.
Yes.
I think all we would say is this. A, that strikes us as a very sensible way to deal with it, one which we had been thinking about, one of the reasons we were slightly late starting. And I would think I would only add this. If any of you go short on the first stage, on the jury bundle point, and we quite understand if one or other you want to take that quite shortly, we would unusually be happy to let you add the saved time onto the time which you're proposing to take on the other points. We don't normally allow that, but so if we get away at 3:45, we all breathe a heartfelt sigh of relief, and there it is. But I think on this occasion, providing we finish by 4 o'clock, of course, we don't mind you carrying saved time through to the second stage of the appeal.
Thank you, that's very helpful.
I hope that's helpful to both of you. It's intended to be. And I think it's also intended to enable the focus of the hearing to, as it were, aim itself at the biggest or longest points.
Thank you. Lord, with that in mind, can I address, please, the first point?
Yes.
I'm very conscious, of course, that there's extensive written representation already made in this case, but it does seem there are certain points that it's incumbent on me to draw in particular to the court's attention, unless quite happy to be told otherwise or to answer questions, obviously, as we go through. Just in terms of the documents, I think the court has the key documents bundle.
Yes, we tend to operate on the main. What have I got here?
Yeah, we've got the ordinary bundle.
Yes, we tend to operate on the ordinary bundle and just do it by pages.
In any event, what I'll do.
Pagination should be the same.
I hope it assists. There is a uniform electronic bundle reference for every document.
Yeah.
And so if I refer to that, if in doubt, that I hope will assist.
Yes, that's right.
But in any event, to the extent there is a key documents bundle, it does contain the statement of facts and information and our written submissions and the appellant's further submissions, which we will come to later, but not for the initial observations. Just by way of brief background, the court knows this is an appeal from the Eastern Caribbean Supreme Court of Appeal decision dated the 27th of February of last year to quash the conviction of the respondent, Mr. Warren Cassell, following his trial and conviction in front of a jury on the 22nd of June 2022 in the High Court in front of a jury in Montserrat. He received a sentence upon conviction of 3.5 years imprisonment. As I say, application was then made and permission obtained to appeal that decision. The background of the case, the court will know there's some background to the defendant and indeed to the case. Again, I can deal with things very shortly just to give you context.
I think you can take it.
Of course.
We've read the papers.
The offending unusually relates to 2007-8, so a long time ago. The previous trial in 2012 led to appeals to the Court of Appeal and the Privy Council. Importantly, the documents that were deployed and relied upon for the purpose of the original trial were identical, in fact more extensive than those, because it was from those that these were filleted in due course for the purpose of these proceedings, and so were with the respondent from that period of time. As the court knows, the money laundering allegation commenced under the incorrect legislation. There was an appeal, and in due course, cutting through all those matters, these proceedings commenced in May 2019, when a fresh summons was laid under the correct legislation. I know the court has access to the indictment, which appears at various stages, but for these purposes, certainly at page 136 of the electronic bundle, but also at 1074, one can see the proposed that became the single count indictment deployed in this case that was relied upon for the purposes of the trial. There were a number of pre-trial hearings from 2020 before the trial in June 2022. The conviction, of course, was appealed. The hearing in front of the Court of Appeal in the Eastern Caribbean Supreme Court was heard on the 17th September 2024, and their judgment was then read and announced on the 27th of February 2025. Of course, you have the judgment. It begins at page 1117 and continues for 30 pages. Now, this appeal, insofar as that judgment and the contents is concerned, really focuses upon extracts of what the Court of Appeal said from page 1136 in the bundle. Because it's from page 1136...
Let's go there now.
Yes, please.
Just before you go there and you just fill us in with the background, what has actually happened to Warren Cassell? Has he been on bail? Has he served any sentence?
He served his sentence.
He served his sentence.
Thank you.
It's important because it's the basis upon which our complaint is made to consider what the court said there from my Lord's 1136 and particularly from paragraph 65. Paragraph 65, the court highlighted the opening address and leads up to, of course, the deployment of the bundles during the course of opening and before witnesses had come along to speak to those documents. So that's the beginning of the court below's analysis. Paragraph 69, the court went on to say it's the practice that each exhibit must be identified by a label or other mark and sufficiently described in the statement. to identify it. It should be made by the initials of the person who will produce the exhibit and a consecutive number. The learned trial judge from the outset of the opening address of the Crown allowed the prosecution to show documents to the jury and allowed the jury to be taken through some of the contents of those documents without them being tendered or marked as exhibits in accordance with approved practice and procedure. And really our complaint stems from those observations and the observations that then continue. The appellant objected to this practice, I'll come back to that in a moment if I may, arguing documents not yet admitted into evidence ought not to be shown to the jury. However, the learned judge overruled the appellant's objection, allowed the Crown to show the documents to the jury prior to them being admitted into evidence. The court stated this: the appellant described the practice adopted as unprecedented and unorthodox. This court must agree with such a description. It's important, because I want to deal with it, if I may, in one go, just to look at their other observations on this point. On page 1138, paragraph 73, this is what the court said. The close of the Crown's case, no application was made, was or had been made for any of the documents referred to or shown to any witness in the matter, for any such documents to be tendered, omitted, or marked as exhibited in the matter. And then at 75, at no point in the transcript of the proceedings of the court below were any documents tendered as exhibits and marked accordingly by the court as exhibits in the proceedings. In fact, the documents do not form part of the record of appeal. That's right, the actual documents weren't copied for their benefit, although the indexes indicating all the documents were. The court went on, this procedure at 77 is highly irregular and unusual in either civil or criminal matters. In the absence of agreement of the parties that documents were not being challenged, the documents ought not to be shown to the jury unless and until they've been properly tendered and marked as exhibits. And in effect, the commentary then goes on to talk of the failure to exhibit the documents and then comment upon the absence of the documents and what it meant in terms of the state of the case. So that's the starting point for our observations about what we say went wrong in their observations in the court below. Taking matters briefly, in our written case, my lord, page 1043, we highlight our submissions, which in summary are set out in the first three paragraphs, which we say are that the court below made error in finding there was a material irregularity in the course of the trial in the manner in which the appellant sought to admit documents into evidence, that the court below was also in error that finding without the documentary evidence the case against the respondent was tenuous, such that there was no case to answer. And in point 3, we say the court erred in failing to identify or consider any prejudice when ruling there had been a miscarriage of justice and declining to engage the statutory proviso. So just breaking those down, if I may, in terms of what we say was the court's error in finding the material irregularity, we address that from page 1044. We say the appeal was allowed on an unreasonably inflexible interpretation of how documents can properly be admitted into evidence. There was, in fact, we say, nothing unusual or irregular in the procedure adopted in this case, that it followed normal practice in terms of document-heavy cases and presentation, certainly in the courts of England and Wales, but also anecdotally elsewhere. And we say the court's ruling has the effect that no case can be opened to a jury without a file of non-contentious admissible documents, or what we call a jury bundle. And that would create real difficulties in terms of how cases are conducted.
Well, unless the defence consent.
But what it means is all the defence have to do is say we object, and then these cases can't be opened to a jury without any detail. But can I come to what actually happened?
Yeah.
In terms of...
But that's the important one.
Yes, of course. Of course.
I mean, it's true in this case, isn't it, that there was no objection until the actual morning of the trial.
Correct.
So in effect, there had been agreement.
In effect, that's what we would say. And also, of course, the point was made that when the point was raised, there was no point being made about the admissibility of the documents at all. It was
It's purely a timing point.
purely a timing. Right.
It may be that I've missed it somewhere, but how many documents are we actually talking about that were in the bundle?
Approximately 600 pages
Yeah.
of documents. Yes. So two bundles, one and a half bundles, one bundle, and then a document of land, file of land registry documents. So what we say is...
It helps, it's the whole of tab E in the electronic bundle.
Thank you.
Sorry, I missed that, Mr. Rose.
It's the whole of tab E, I think, in the electronic bundle.
Well, we're not on tabs, so that doesn't really help.
Forgive me.
Oh, yeah.
I'm sure you can
I was looking at the bookmark to the right.
If you do click on the relevant thing, it's E, other documents, and it says it's headed Jury Exhibits Index Bundle 1 starting at page 1216.
Thank you.
It starts at 1216 and ends at 1661.
Thank you.
Yeah.
So in fact, it's shorter because, again, as was foreshadowed prior to the trial, documents were taken out that were considered irrelevant.
Yeah.
But on this point, and in terms of the history of this case, and as already observed by the board, what happened was there was advance notice in pre-trial hearings of the Crown's proposal in terms of presentation of this case. A decision was taken that the only practical way to present a case involving so many documents of some complication which required explanation was to have jury bundles. And that was conveyed in the pre-trial, that approach was conveyed in pre-trial hearings. In fact, over 2 years prior to the actual date, if one goes to the electronic bundle at page 1064, 1064.
Thank you.
There is a note for the hearing of the 27th of March 2020, when the trial had originally been scheduled to take place during that year. Of course, we had COVID, we had other matters, and the trial was delayed till 2022. But in advance of that date, a number of matters, if one goes through, there's quite a bit of detail, in fact, on a number of topics in this document. A number of matters were addressed. So the indictment and observations made, which I don't need to go through, of course, for the purpose of this, but it touches upon matters that may be argued later, will be argued later. In terms of the approach to the indictment was fleshed out within that document at the beginning. The Crown's observations, for what they're worth in terms of what had to be proved, were set out at page 1065 in terms of the law and the money laundering provisions and how the indictment should be phrased, and criminal property.
I mean, it's paragraph 26, right, at 1072.
Thank you. Those I'm actually dealing at 1066 and going through.
Yeah, but for this point.
For this point, my Lord has it precisely. So for this point, indeed, towards the end of the document, paragraph 26, there is a heading, a jury bundle. So this was provided to the court prior to the hearing, indicating the Crown proposed to rely on those documents served within the exhibit bundles 1 and 2. And there's no doubt about what those were. They appear on the face of the court documents on a regular basis. Will seek to reduce the documentation further to what is considered essential or important for trial, and that is what happened. We made the observation some were inadmissible, they were taken out.
And so did you serve the definitive jury bundle by the 24th of April, which is what paragraph 31 says.
Yes, I don't have the, we have the jury indexes which were provided, but yes, those were served, and the opening was also served,
Yep.
which follows this document. So, just looking further down, at further directions, paragraph 31, we indicate that it would assist the court to have a detailed note of the Crown's case. That can be served. That date was put back. What one can see from the opening, I'll take the court to in a moment. That was served a bit later in 2020. And the observation at 32, it would assist to have notice of any points of law that may be advanced prior to trial. We suggest all parties have until the 22nd of May to set these out. In summary, no point was taken about the use of jury bundles and the opening, which was then provided. So the indictment is then...
Was Mr Cassell acting unrepresented at this stage?
No.
He was represented?
He was represented. It's important to recognise he was represented all the way through proceedings until his trial, when he made the decision to represent himself.
I mean, this is all consistent with, you know, cards on the table in criminal
Yes.
proceedings, which is the modern approach.
Yes.
Yeah.
So that's what happened. And the opening notes, my lord, at page 1075, I don't need to go through, of course, the detail of what it says, but it's not a case summary. This is the opening note. This is for the trial, the presentation of the trial. And one can quickly see, when one looks through the comments made within it, for example, if one goes to paragraph 8, we start to get to reference to the exhibits in the case, the documents that form part of the jury bundle.
So, I mean, was this note given to the jury, or was this just read, effectively read to the jury? Yeah.
So this note was provided to the defence, provided to the court. The trial, the case, there was no advance notice of objection. Of course, physically at court, we had the files at the bench to be handed out to the jury. And it was at the point that I started to hand out the files that the objection was made. But the importance of this is that within the opening note, all the detail of the documentation is referred to in terms. So what one can see, all the exhibits there, which all cross-refer to the jury bundle documents. I don't need to go through all of those. I can if you'd like me. But from there, it refers to the details of the parcels of land, to the formal documentation, to the plans that we used, all the detail that was relied upon in the jury bundle.
So these crosses 507, etc., these are the references to the jury bundle?
Yes.
Yeah. And this opening note, as I understand it, this was before Mr Justice Morley? Is that right? Has he actually...
It was before Mr Justice Morley, but then the trial judge was Mr Justice John, but Mr Justice Morley made the vast majority of the pre-trial decisions.
Yes, but I see. Okay. So when was this opening note produced for the benefit of the defendant?
June 2020,
How long before the trial?
2 years. It may be of some assistance because there is a danger, and actually this is the practical issue we had at trial with all the references, getting lost with cross-referencing. Can I just ask the court, please, to have a look at the jury bundle index itself, because it may help with the referencing and how things worked. And if the court were to go, please, to page 1216 in the electronic bundle.
Yes.
This is the bundle 1 index, which we created. It goes to a total on page 1218 of 70 items, and it's set out, because of course one has to bear in mind, and this is where the history is important, all these documents had been previously exhibited by the witnesses. They had already been given, if you like, the exhibit references, which one can see from the left. One has a column for the numerical number, then the initials and number of a particular exhibit. So for example, OMR1, that's Owen Rooney's exhibit number 1,
Oh, I see.
minutes of a board meeting, and then the
So when you say they'd been exhibited, is that because they'd been exhibited in the previous trial, or they'd been exhibited to some form of statement, or when you said they'd been given a reference number or an exhibit number, at what point?
They always had. The original exhibits, when they were taken in form of the statements, have, as is the usual course of criminal trial, generally the initials of the individual who produces, and then a number indicating the number of the exhibit. So that is the order they originally were provided. The further numbering was adjusted for the trial because of the change in pages, but the original exhibits, if we have a look at any of the exhibits, shows the original exhibits stamp, lettering, and the numbering at the bottom. So if I can explain.
Just so I've got it right, the X numbering in the opening statement refers to the right-hand pagination in the index, is that right?
Yes. So, can I take the first example? If one goes to page 1220, electronic bundle 1220, which is the minutes of the first meeting. At the bottom of 1220, one sees a number of references. They include the original exhibit reference to the right, OMR1. The 1220, of course, is our reference. In the middle of the page is the original exhibit pagination. Although the exhibits were filleted to reduce the number for the reasons I've explained, to avoid complication, that pagination didn't change. So that page 1 is the page 1 that appears at the top of the jury index. And following that through, if one were to look at OMR2, page 5, that does indeed appear as page 5 on page 1224. So we could foresee the complication of renumbering again and again, and it clearly seemed that the answer was to retain and make clear in the index, as we did, the original exhibit, who produces, so hence OMR and the sequential numbering, and then the page within the bundle in which they appeared. You will notice that there are occasionally pages missing, simply because, no mystery, it was decided to take, as I indicated, to take those pages out. And that is how the jury bundle was created. That is what the exhibit index indicates, and that is also the position that was taken with the second bundle that begins on page 1464. Precisely the same approach taken, that is the sequential numbering of the item, the original lettering and number of the witness, and then the page that appears, I think, always at the bottom of the copy of the document. So that those documents, I say, all those exhibits provided in advance, nothing was added, but they were reduced for the purpose of the trial, and as set out in the note indicated, we say made clear that they would be deployed in the course of the opening in the way that we had always proposed. So that's the background to the objection that was then raised as the efforts were made to open the case to the jury, and it may be of some assistance to look at the electronic bundle and the transcript of what occurred at page 148, please. At the very bottom, having made some introductory comments, I said at line 30, so what I'm going to ask you to do, in fact, now is for Mr. Gordon to pass out to you a file of documents which I'll take you to 1 or 2, and it was at that stage that the objection was raised. So the jury went out. Page 149, Mr. Cassell raised his complaint that can be seen from line 12. Never in the history of the court system in Montserrat has the jury been given documents that have not yet been admitted into evidence. And observations were made. We responded at line 21, and my observations along the lines of, this is a case of money laundering where the documents have been with the defence for well over 2 years. Prosecution have invited comments, objection, etc. The court intervened on page 150 to press Mr. Cassell about the nature of the objection. And of course, this is important in terms of the overarching picture. Thank you, Mr. Jury. Mr. Cassell, am I correct? The bundle has been in your possession for a period of time. You've been given an opportunity to object to any of the documents within the bundle? No. You're not given that opportunity. With respect, I think he's missing the point. He's pressed. You're given an opportunity. I just want to know, you object to any of the documents in the bundle? And he said, yes, we have. And you address these matters. And then this, we were never given an opportunity to address. If he had indicated that he would go outside of the normal practice and show the jury at this stage, we would have objected. It is not permitted by law. Then importantly, we're not objecting to the documents themselves. I think it's right to say with all the documents that were then used, the court having allowed me to proceed to open by reference to them, no objection was taken, in fact, to any of the documents deployed. And that was clarified on page 151, line 6. I should say 5. We've not objected because the proper time to object is when the Crown intends to tender it into evidence. That's 1. Number 2, again, our objection is not to the documents themselves. It's simply to them being shown to the jury at this time, unorthodox, unprecedented. Of course, those are the words that are picked up by the Court of Appeal and form the basis for his successful appeal against conviction. The court observes, reflecting without going into the full detail of the background, over a period of time, the judge said, I'm aware there had been hearings. I personally indicated that all legal objections ought to be addressed prior to the date of hearing. I'm aware that I sat also, my brother, Justice Morley, sat and addressed some of the matters before the court. The objection today is the handing out to the jurors at this stage the bundles. Am I correct? And he said, that's correct. And the court presses further. The sole reason for that objection is that practice does not exist in the Eastern Caribbean Court. That is correct. So I then picked up on the point, obviously, about the objection and reiterated that we wished to have them in front of the jury to explain in opening, as set out in the written opening, and the court ruled on page 152 that that would then be appropriate. So that's what happened, that's what took place, and then of course the trial commenced with the witnesses, and I don't need to go through, and whatever the court would be assisted by, but the witnesses then came along, as the court would have seen, to give their evidence and identify each of the documents. They were referred to the bundles that the jury had. The jury, it's right to say, did have highlighter pens. I know a point was made by that in the court below. And
so they were properly tendered in evidence at the time at which each witness was coming forward. They were actually asked, is this your exhibit or whatever it might be, or words that effect?
Every document was taken.
I suspect that's a contentious point.
It may be. I hesitate to give a
You
blanket.
need to give us an example of how you say it was done.
Yes.
By reference to what I assume is an available transcript.
Yes, of course. So just dealing with Owen Rooney.
Yeah.
So Owen Rooney, of course, took up a lot of time, 2+ or thereabouts days of of evidence, and his evidence, what it's worth, begins at page 226 of the electronic bundle. And from page 226 to page 301, if one looks at page 227, he's asked the question by me, have you also been provided with bundles of documents including a file which includes something like that which I'm holding up? And he says, yes, I have. And these are introductory comments for his evidence. Do you also have access to a plan showing the Providence Estate? Yes, I do. And he's asked introductory questions before he is then asked in detail about each of his exhibits in turn. Just go to pick up the point that my Lord addresses.
I think what may be separating you is one thing to say he's shown a document from the witness bundle that happens to be one he originally produced. It's another thing to say, are you producing this document as a document you can verify?
Yes. So what happens in terms, in fact, sorry, I was looking for my list, but if one goes to page...
Well, you can say 231, for
231,
example. I mean, he actually says, in answer at line 18, on the 8th of September, wouldn't I drafted minutes of a meeting,
Yes.
etc. And then the question is, so members of the jury, look at page 1, it's the minutes of the meeting of the board of directors. Answer, yes. 6 lines down, it says, that was your attorney, yes, etc. So,
and that continues for the duration of his evidence.
and then he goes on to pages 5 and 6, the next page. So there's not a laborious process by which each and every time he refers to a document, it's remarked as an exhibit. He's just asked individually questions about the documents which
So
he speaks to.
He could have been asked every time, and do you formally produce this in evidence? But that's why it's important to look at the background as to how things were produced. And he was taken to each of his documents. So taking those examples, my lord, the landholding licence, page 232 of the transcript, meeting minutes at page 234, and all the other topics, and I'm not going to go through them all, but as one goes through, each of the documents was shown to him, and he spoke to those documents that he had produced originally by his own reference.
Yeah, so again, there's another one at page 234, in the middle, line 14, go to page 7. Do you see that? Yes, it's minutes of a board of directors that you and Mr Wood. Is that right? That is correct. So he verifies what the document he's been asked is.
Yes. So that happens all the way through. There might still be taken a point about, well, is it clear that the documents were in fact, for these proceedings, going to then be produced in the files and formally exhibited in some way? Can I take the court, please, to a reference in relation to that? Because my lord has the point, and there are tens of other references I could go through, but I won't unless I'm invited to. But if one goes to page 269, please. And if one goes to line 11 on 269, we were going through the process of the witness going through all these exhibits in the files that the jury had, and then this question at line 11. Can I ask you with that in mind to look at page 121? And I don't need the court to look at page 121. That's the real estate listing for some of the properties that appeared in the case. But this, in front of the jury and, of course, in front of the court, my lord, just so there is clarity on this, because we put it together as a bundle, the officer in the case will exhibit all these items as officer in the case in due course, but it's your exhibit, is it not? Yes, OMR 45. So really, confirmation of that approach being ventilated openly in front of all parties during the course of Mr. Rooney's evidence. So that was the procedure adopted. As I say, I don't think it's going to assist this board to go through all the references with all the witnesses, but that was the approach taken with all the witnesses who produced their exhibits. They were taken to all of their items. Bundle 2 was the land registry documents confined to Shelley Isles. She was taken to those, and she indicated she was asked to produce certified copies of the documents, which she did, held in the land registry files. And again, she was asked about each in turn. And it's right, there was quite a bit of banking evidence, and again, that was adduced in the same way that the officers from the various, the Bank of Montserrat, Bank of Canada, spoke about producing the documents from the records. Of course, they didn't have first-hand knowledge, but producing it for the court, and then that being contained within the files. So it then came to the officer in the case at the conclusion, and she was asked generally, her evidence, I think, begins from page 356. And just taken from the top, because in fact there was financial analysis, there was so much to be reduced that what happened at line 4 was she was asked, I think one of the things you did was a financial analysis, looking at the bank statements, analysing them. Yes, I compiled in a spreadsheet. I can say there was no objections. One can see at line 13 there was no objections to that. That was the spreadsheet which set out the total financial loss, the indictment figure of 855-odd thousand Eastern Caribbean dollars. That's what that document was. And then this, as I foreshadowed, at line 15, asked the officer of the case, you've had a look at all the exhibits in this case? Yes. You formulated the items in both of the files in front of the jury? Yes. Now, I could be criticised and told I should have said something further to formally exhibit, but that was the process which had been indicated, as we've now seen, prior to trial, within the opening, with the witnesses who were taken through, certainly from Mr. Rooney, and here finally in terms of the officer in the case. So that really is a short-form summary of what happened.
I'm running forward all the time, it's 5 minutes because we started late. Mr. Rogers, you're about 4 minutes away from your first deadline.
Well, I'm very grateful, and I wasn't proposing to necessarily use the allotted time at all.
No.
As it happens, really, that is the full explanation of what took place.
Okay.
Thank you.
Yes.
Thank you, Lord. Well, Lord, I should say it is a slightly convoluted timetable that we've agreed, and for our part, I think we would have preferred that we started on the merits of the case, but my learned friend is the appellant, and he's perfectly entitled to insist on starting, and in those circumstances.
If it's any comfort, we had canvassed that as a possibility, but well, you've done what you've done, and it seems to be working.
It's so far. My Lord, before I get into the merits of this point about the documents, can I just take your lordships to one further reference in the transcript, just completing the otherwise pretty full account that my learned friend gave of what was actually said in the course of opening about the documents. And it's just to pick up, I'm sure your lordships will have seen it, but to pick up the exchange on page 152, right at the end of the discussion about the documents in the absence of the jury. At line 6, your lordships will see that the judge says the purpose of handing them out at this stage is simply to refer, and not a question of admission into evidence at this stage. And my learned friend says yes. And the judge then rules that the bundles can be shown to the jury. My Lord, in our respectful submission, that's quite important because it sheds some light on the substance of the Court of Appeal's objection to what went on in this case.
Sorry, page 152, line 6.
Yes, my lord.
The court.
Sorry, I'm on the wrong page. Yes, thank you very much.
In other words, it makes clear at that stage, my learned friend makes clear that by handing the documents to the jury, he is not at that stage seeking to have them admitted into evidence, but rather that's simply a matter of referring to them at that stage, and that's an important distinction in our submission. But, my lords, as we've said in our written case, the starting point on an issue like this, we respectfully submit, is that this is fundamentally a question of the practical mechanics of trial procedure, and so the view of the Court of Appeal of the Eastern Caribbean ought to carry considerable weight. That's not to say, of course, that its view must prevail, and of course, even in matters involving questions of practice at a local level, the board will intervene if it thinks that there's been a substantial error of principle. But it's important in our submission that when a court in the Eastern Caribbean says that what happened here was irregular, indeed highly irregular, it's important in our submission to take into account that that is a view which is entitled to some deference. Indeed, we pointed out in our written case that the only learned Justice of Appeal who gave the judgment was Justice of Appeal Price Findlay. At the time we wrote our case, we described her as the acting Chief Justice. She's no longer the acting Chief Justice because she is the Chief Justice. She was sworn in last month. My Lord, that's important in our submission on what is essentially a question of practical procedure.
This wasn't even by the Court of Appeal being treated as a particular procedure unique to Montserrat.
No. But I suppose the way I put it is this, my Lord. The starting point, we would respectfully submit, across the common law world, is the way in which the Court of Appeal put it in paragraph 67 of its judgment, which is page 1136. The point about it being trite law. It is trite law that all documents, photographs and reports used as evidence must satisfy the requirements of the law to be admitted as evidence. During a trial, each piece of evidence should be marked and formally admitted. Such exhibits must be marked and formally admitted into evidence before they can be considered by the judge and jury. So there's a process to be gone through. And your lordships will have, no doubt, have read.
But what's your objection? Is it that there wasn't a formal process during the giving of evidence of marking and of the documents as each document was shown to the witness and identified and verified? Is that your objection?
My Lord,
or is, as I understood it, your objection to the procedure which is absolutely standard, certainly in England and Wales, and I suspect in many other common law countries, or in document-heavy cases, of simply allowing the prosecution to open the case, showing documents to a jury?
My Lord, it's both. The objection is to what happened in the course of opening the case. I appreciate your lordship, and I don't of course quarrel when your lordship says that it's commonplace in England and Wales and other common law jurisdictions for there to be jury bundles in heavy cases. But, my Lord, that process can only take place, I respectfully submit, by consent of both parties. Obviously, in a case where it's document heavy and certain documents are inevitably going to be admitted into evidence because they're obviously admissible evidence, it makes sense for both parties to agree.
Do you say it's open to any defendant in facing a document-heavy fraud case, just simply to say, nope, don't agree, prosecution will have to open this case without any reference to any of the documents?
How that is dealt with procedurally will depend upon the short answer is yes, but how it's dealt with procedurally will depend upon the particular jurisdiction.
Yes, it's open to a defendant.
Can I deal with it in stages, my Lord? It's open to a defendant to say, at whatever the appropriate stage is in the procedure that's being followed. If we assume we're in a jurisdiction where there is a sophisticated provision in place for pre-trial hearings, then it might well be said that's the time to say it. I can see that entirely. And it may be that at that stage, if the defendant says, I intend to object to the admissibility of any document, then the court would need to consider whether it could make a ruling at that stage that the document is admissible.
But I'm trying to tease out, I don't think that's quite the point you're trying to make. I mean, obviously, if a defendant says at any stage before a jury is shown a bundle, I do object to the admissibility and evidence of a number of the documents which I've seen in the pre-trial process, then generally speaking, I think the understanding is that the judge or a judge in the pre-trial process will rule on the admissibility of the documents in the absence of the jury. So it should never be the case that a document, the admissibility of which is disputed, gets shown to a jury.
Yes. Well,
but I understood your argument to be that even if a defendant says, I don't object to the admissibility of any of these documents, but I do have the right to say at any time you just cannot open the case to the jury by showing them any documents. You must open the case to the jury without any documents being shown at all, because they have not yet been formally admitted in evidence. I mean, that is your case, isn't it?
My Lord, yes, it is our case, as in this situation.
What practical sense does that process serve?
Well, my Lord, we respectfully submit is an issue which is quintessentially one for the local court to determine. Essentially, our point as regards the as it were the spectre that Your Lordship raises of a judgment in this case. My learned friend raises this spectre too, causing chaos across the common law world, is that in this case the Court of Appeal was entitled to say that in the Eastern Caribbean, then absent consent, that there is the necessity of all documents being formally put into evidence. But one doesn't need to go quite as far as that in this case, because there wasn't in fact in this case any moment at which the court did rule upon the appropriateness or otherwise of the documents being put before the jury during the opening submissions. I should make clear that that's only one aspect of the matter, because the key point.
It ruled on it at line 9 on page 1136, didn't it? And that's the judge's ruling.
On page
1136, line 9.
Having heard both parties in this matter. Yes, but that was on the basis of the assurance that the purpose of handing out at this stage is simply to refer, and not a question of admission into evidence at this stage. So that raises that we then come to the separate question, which is, were the documents in fact admitted into evidence? And my respectful submission is that the Court of Appeal was entitled to say, in this case, no, they weren't, because they were never formally admitted into evidence. Your Lordships, I think, noticed that we were shaking our heads a bit when my learned friend said, yes, these documents were all admitted into evidence. I accept, of course, that witnesses did speak to some of these documents. The important point, however, is that they were never formally entered into evidence. And that's important in my submission, my Lord. In a criminal case, it is important that there be a degree of formality, not least so that it is clear what the time is at which the document is being admitted, because that's relevant to the question of any objection. And can I just show you...
Can I just be absolutely clear about your submission? Here we've got a case where the defendant has, in effect, consented to a process in the sense that he has indicated that he's got no objection to the admissibility of the documents. It's then the case that, as I understand it, you are now saying, well, there's nothing wrong with a jury bundle. It actually only becomes a problem if subsequently there is no formal admission of the evidence. But that's not what the Court of Appeal said. So are you now, in effect, accepting that it is not a problem that there is a jury bundle provided the defendant is consenting to that, which I think we've got here, so long as you have formal subsequent admission into evidence?
I'm not sure I am conceding that, my lord. We submit that in this case, where objection was taken to the jury being shown documents which had not yet been admitted into evidence, that objection ought to have prevailed.
So you are saying that irrespective of whether there's a challenge to admissibility, and in fact in this case the defendant says, I do not object to any of these documents, nevertheless the defendant can say, and should be upheld if he says, I just want the prosecution to have to open this case without reference to any documents.
Well, my lord, had this matter been...
You're saying he has a right to say that. If it's all to do with agreement, he's got a right.
My lord, I can see why that by itself is an unattractive submission, because that obviously would cause difficulties. But the answer to it is that that's not quite this case, because what one would expect to happen in a well-ordered and well-regulated system is that these questions would be thrashed out in advance. That for whatever reason in this case,
out in advance.
Well, my lord, we wouldn't concede that they were. My learned friend, I noticed, said that it was. I think he said it was in effect agreed. In effect, there had been agreement about the admissibility of the jury bundles and/or about the jury bundles being put before the court. But my learned friend wasn't able to point your lordships to any either a written agreement between the parties or documentary material from which one might infer an oral agreement, or to any ruling of the court. So we ended up at trial in a situation where...
The judge asked Mr. Cassell, and Mr. Cassell said twice, I do not object to the admissibility of the documents, to any of the documents. It's not the admissibility I object to. He just said, I just don't want the prosecution to show them to the jury at this moment.
Well, can I illustrate, my lord, why...
But that's right, isn't it? I mean,
yes.
I mean that is the transcript.
I can't dispute that, my lord. But the point is more subtle than that in my submission, because documents are not simply either admissible or not admissible. They are admissible to prove certain things, and that there is an important benefit from the procedural rigour of requiring the court to address the admissibility or otherwise, and for what purpose they're admissible of particular documents. Can I illustrate that with two references, my lord? First of all, just in the Criminal Procedure Code, which this illustrates why it's important that there be a moment at which one can be clear this is the document is being admitted. If one goes to page 1792, one sees, hopefully, paragraph 157 of the Criminal Procedure Code. The proper time for making objections at a trial on the grounds of improper admission or rejection of evidence, or any irregularity or informality in the proceedings, etc., shall be as follows. A, if the objection is to admission or rejection of evidence at the time of such admission or rejection. So it's important for the purposes of the rules that there be a moment at which the document is either admitted or rejected. What went wrong in the present case?
But hang on, you're not just taking that literally, are you? I mean, it's not to say that, for example, if a defendant knows that reliance is going to be placed on a particular document which he objects to, that cannot be raised or shouldn't be raised in, for example, a pre-trial hearing.
No, I'm not saying that, my lord. No, because that would be. Well, this is a procedural code rather than I think something which irretrievably rules out any further debate about the admissibility or otherwise of the document. But the important point is that it emphasises that there needs to be a moment at which it's crystallised, should this document go into evidence or not. And what happened in the present case was that in the course of the opening, the documents were shown. There was objection to that on the part of the defendant. Even if I'm wrong to say that he was entitled to make that objection, the basis of the documents going in was that they weren't being admitted at that stage. They were simply being shown, as it were, de bene esse to the jury. Because the question of admissibility was going to be dealt with subsequently. And it's right to say, of course, that in relation that although there was never the formal process which one frequently sees, and one saw, for example, in the previous trial of this case, many of these documents were put in evidence in the previous trial, which also reached the board a decade ago. And in that trial, it was done in the more formal way. Each document, there was the exchange between the parties that one sees in transcripts. May this be admitted as Exhibit AB1? Any objection? No. In it goes, and so on.
But I don't understand how this is supposed to work. I mean, if you go to the Court of Appeals decision at page 1138, I mean, they say, in the absence of agreement of the parties that documents were not being challenged, the documents ought not to be shown to the jury unless and until they've been properly tendered and marked as exhibits. I mean, you say that's right. Paragraph 77 at 1138. So the defendant can just simply say, well, I just don't agree. Irrespective of whether I intend to challenge the admissibility of any documents, I just don't agree that they can be shown to the jury ahead of them being formally put to a witness. So that would mean that the defendant would have an absolute right, just by withholding his agreement, to prevent the prosecution from opening a case by reference to any document.
Yes, in the same way that a defendant is entitled to put the prosecution to proof, even if it's very inconvenient. The fact that one can see in advance this document is bound to be admitted into evidence because it falls within the scope of a document that would be expected to be admitted, and it's very likely that when it's put to such and such a witness, the witness will say, yes, I recognize this, that is my signature, that this is the document. The fact that one can see that's what's going to happen may well be a reason for sensible defense counsel to say, well, let's let it go into evidence and focus our energies on getting out our client's case as to the provenance of the significance of the document. But in principle, in my submission, the defendant is allowed to do that, in the same way that the defendant is allowed to put the prosecution to proof on every aspect of the matter. After all, what if otherwise, and it might not be a very sensible thing to do in every case, one can see that. And if there's a narrow legal reason that one is going to be taking at the moment of objection, then that clearly could be separated out and dealt with in advance. Suppose the defendant simply wants...
Surely the defendant cannot say is, I do not object to the admissibility of this evidence, but I'm not going to allow the jury to have a bundle.
My Lord, that's a slightly different point, I think, from the one I was seeking to address, which is whether, as a matter of generality, a defendant is allowed to say, to Lord Snowden's point, whether, as a matter of generality, a defendant is allowed to say, I object, as per the Court of Appeal, I object to this going to the jury unless and until it's been put into evidence. Because the defendant's perfectly, it may not be a very sensible course, but a defendant's perfectly entitled to say, I'm not going to allow this into evidence until a witness has not, until A, any legal questions have been sorted out about its admissibility, and I can see that sensibly could be dealt with at an earlier stage, and B, the witness has actually said, yes, this is my document. Suppose the defendant wants to take a chance that on the day the witness will say, no, I'm afraid I don't recognize that document. Then the fact that his counsel...
Well, I have to say for myself, I just don't follow the distinction that you're actually drawing. If a defendant has actually said, I'm not objecting to the admissibility, he cannot then, surely as a practical matter, say, at the time at which the jury bundle is being put to the jury, I object. Because otherwise you are taking the extreme point that jury bundles cannot be put forward to a jury, whatever the agreement of the parties, if the defendant at that moment in time says, I'm not having it.
And I wouldn't go that far. Plainly, I have to accept if a defendant says in advance, I do not object to such and such a document going before the jury, then it can't be open to him later on at the moment.
That's what he said here.
Goes, well, that's...
No, I mean, I'm just... See, the other way to read paragraph 77 is to pick up this point, is one way of reading that is to say, they say, in the absence of agreement of the parties that the documents were not being challenged. Now, isn't that exactly what Mr. Cassell did here? He did say twice, I'm not objecting to the admissibility of these documents. I mean, so reading that a slightly different way, and isn't that what he actually said?
Well, can I illustrate, my Lord, one practical example of why it's important, nevertheless, that there be a proper process of the documents being, as it were, filtered through the admissibility process, not only as to whether they can or can't be shown, but also as to what it is they're admissible for. And just illustrate this by reference to the Virginia court default judgment, which of course comes into play in our case on the merits. But your Lordships will recall that in this case there was a judgment of the court in Virginia, which was a judgment in default in a case which Mr. Rooney had brought against the defendant, seeking to get a declaration from the court in Virginia as to whether the transfer of the 60% of the shares from Mr. Wood, who was the majority shareholder, to the defendant was valid or not. And as your Lordship will have seen from the papers, this was the subject of discussion last time the matter was before the board, and there's a very important point to be made about it, which is that it was not a decision that was binding on the defendant, though it was, as the board held last time round, on the other prosecution, and it must apply to this case too, we accept. It was admissible as evidence to show that Mr. Rooney was objecting to what was going on. Now, my Lord, that important point of clarification about why the document was being admitted and what for would have emerged had a proper, what I would call a proper or a formal procedure been taken.
But if Mr. Cassell had said in answer to the judge's question at the electronic bundle 150, I don't object to all of the documents, except I do object to the jury being shown the judgment of the U.S. court.
Well, I agree. That would have made my life easier if he'd said that.
That was his opportunity to do it. The judge said, "Do you object to these documents?" He said, "I don't object to the admissibility. All I object to is the jury being shown them at this stage."
Yes. Well, my Lord, that's a. I mean, there are two distinct points here. I don't need to succeed on them both in order to succeed on this element of our response to the appeal. The first proposition is were the Court of Appeal right to say that nothing can be shown to the jury in advance of the document actually being formally or being spoken to by a witness unless the parties consent. On that, we simply say, well, that's very much a matter of local practice, and they're entitled to say in the Eastern Caribbean that's how we do it. When they're entitled to say that.
And that will mean that every defendant in the Eastern Caribbean jurisdictions will simply say, don't consent, prosecution have to open the case against me without reference to any documents. Not obliged to agree, not obliged to consent, don't have to give you a reason. I mean, what conceivable practicality would that serve in any...
Well, it would enable defendants to reserve their right to see what happened when the prosecution tried to get the document into evidence. Because it's very easy to look at this when one's thinking about documents that it's obvious are going to be put into evidence, because we know the prosecution is going to call a bank clerk who's going to say, I printed this off from the bank software. But there are cases where there are documents which...
I understand it might give a defendant some difficulty if they'd only been shown the documents, a day or two before the hearing and they hadn't had time to consider them. But these documents had been in evidence in a previous trial and given 2 years before this trial. I mean, what conceivable problem did Mr. Cassell have? He didn't evince any problem about identifying the admissibility of any of these documents.
Well, the fact they've been in evidence in a previous trial is neither here nor there, my Lord, in my respectful submission. That was a separate trial. The prosecution has to start again when it retries something.
Okay. Well, he had the documents too. He had the documents.
Yes.
2 years before.
He had the documents, and he was perfectly entitled in my submission as a defendant to. Well, he would have been perfectly entitled as a defendant to say, I'm not going to admit. I'm not going to allow the prosecution to show any of these documents to the jury until and unless they have properly established a foundation for doing so in the normal way. That might or might not have been a good idea in terms of the tactics of the case, but it's something as a defendant in a criminal case he was entitled to do in my submission.
Do you not have a potentially additional problem in this case, which, as I understand it, because Mr. Cassell was self-represented, the prosecution forewent a closing speech. So everything it wanted to do by way of explaining the case had to be done in its opening. So in a situation where it's not going to have a closing, it would seem to make the proposition for which you're contending even more remarkable.
Well, my lord, I see the force of that. I think I would want to look at whether it's actually entirely right as a matter of law that they had no right at all to a closing speech. I know everyone.
No, and I'm not sure it goes that far, but it seems to be.
But I see your lordship's point. But that may be so. But that's not a consideration which, in my submission, can override the defendant's right to say that I don't wish the jury to be shown any documents until and unless a proper foundation for them to be admitted into evidence has been established. Okay. Can I just illustrate? Well, I was seeking, my lord, just to illustrate.
And the proper foundation, you say, can only be done during the course of giving evidence by the witnesses, formally identifying the document, and then they're being put into evidence.
Well, unless and until a witness says this document is such and such a thing, it's a piece of paper.
So you are saying, I mean, I think your first proposition is as stark as saying the defendant in any case has the right to prevent the prosecution from opening the case by reference to any documents, because ex hypothesi they will not have been put into evidence at that stage, even if he has no objections to the admissibility, even if he's had them for years, and poor old jurors will just have to listen to it, completely blind to all documents.
It's possible, my lord, that some of the.
I'm
yes,
putting it.
That's the logic. That's the logic of my position, and I can't shrink from it.
Okay, that's fine. I just wanted to make sure I had understood.
But one could. I mean, one could mitigate. It's a little way away from this case, but one could mitigate that, for example, by I suppose by saying that the prosecution can tell the jury, and the prosecution, an opening speech is the prosecution telling the jury what it is they propose to prove and how they propose to prove it. So the prosecution will say, you will hear from Mr. So-and-so who will tell you that this is what's happened. Yeah. And the logic of that is they can say, you will show from Mr. So-and-so who will show you some documents which proves that this will happen. And I don't know, I suppose, conceivably, if the jury can be allowed to see documents de bene esse in the same way as a judge, I suppose conceivably with appropriate directions from the judge, the prosecution could be allowed to say the defendant hasn't doesn't accept these are genuine documents, but these are documents in due course we'll call a witness to tell you about, and it'll be up to you to decide whether these are genuine documents or not. But that would be about as far as it could go. But in my submission, there certainly isn't simply a right on the part of the prosecution to say, I'm going to show the jury all the documents which in due course I intend to seek to prove.
Even where there is an express statement by the defence that they're not objecting to their admissibility.
Well, my lord, that's what...
as appears to have happened here.
That's what makes the case... I quite accept more difficult in my position. This is one of the difficulties of appearing in front of a court which is entitled to lay down much more general propositions, is that one deals with the general propositions as well as the specific case. I accept in the present case one needs to look quite carefully at why what it was that objection was taken to, and I accept, of course, that that Mr. Cassell says that he doesn't object to the documents themselves. But I still haven't got to my point. I wanted to just show you, Lordship, to illustrate why it's not just quite as simple as that, because a document can be admitted for one purpose but not for another. And that, I was talking about the American judgment, which it's a significant part of our complaint about the way in which this case was conducted, though by no means the most significant one, that the jury was repeatedly told that the transfer of all the of the 60% of the shares to the defendant was null and void because a court had said so in America. And that had a more formal process of admission of documents into evidence of the sort that the Court of Appeal was advocating taken place. That issue would have been crystallized at that point, because at some stage my learned friend would have said, would now have said, I'm now going to go to this document, and there would have been an opportunity for a debate. Instead of which, what actually happened, my Lord, was first of all, the point is raised in opening. That's page 167. Where at line 11 on that page, my learned friend says, so by this time Mr. Cassell, obviously interested in the property, had gone to see Mr. Wood and had purported, I say purported to buy the shares because in due course a court in America considered this and annulled the whole agreement. They said it's null and void, you're not allowed to do that. And he says, we'll come to these documents in a moment, but the point about this is it's been done without Mr. Rooney being consulted. And in fact, let's go to the document. And then he takes them to page 248, which is the judgment of the American court. So that's the matter being dealt with in opening. Now, I suppose your lordships might say, well, it's okay if it's okay to refer to matters in opening subject to them subsequently being proved. In fact, the way the document, because this rather informal approach has been taken, in which there's simply a sort of bundle of documents before the jury, the next time this document is referred to, the American court judgment, is actually in the cross-examination of Mr. Allen, and the re-examination, forgive me, Mr. Allen. Your lordships might remember Mr. Allen was the retired silk who was giving evidence, in fact, about the fact that he'd purchased, he thought, from Providence Estate Ltd, one of the lots of land. But the defendant...
Can I just pause just for a moment?
Yes.
Because I'm not sure you're entirely right about that. At paragraph 31 of the opening note, i.e. you've shown us the transcript, I mean, Mr. Cassell knew that that's exactly what was going to be said, because if you go to page 1082, paragraph 31, he knew from the opening note that he'd been provided with that the prosecution were going to say to the jury in opening that the court in the US made a legal finding that the transfer of this share to Mr. Cassell was illegal and null and void on the 3rd of October 2008. So, I mean, it's not as if this point suddenly hit him during the course of opening. In the transcript you've just shown us, he knew that the point was going to be made about the US proceedings quite a long time earlier. So he had the perfect opportunity. I don't know when he dispensed with his legal representation, but certainly he and his lawyers would have had the opportunity to consider whether, in answer to the judge's question, do you object to the admissibility of any of these documents? He could have said, no, except I do object to the US court proceedings being referred to because, and then made some objection. I mean, this didn't just come up at the trial.
No, I accept that, my lord, that the point was, yes, I accept the point was flagged, or the intention to rely on the judgment was flagged in advance. I can't dispute that. But what happened in practice was that the objection was taken to the as your lordships have seen, objection was taken to the jury bundle being shown to the jury in opening. That was then resolved by the court, but on the basis that it wasn't a question of admissibility at that stage.
Yes.
So rightly or wrongly, the question of whether the document was admissible, and if so, for what purpose, was postponed into the body of the trial.
And the prosecution took the risk that if subsequently the document wasn't admitted into evidence, there could be an argument that there had been a mistrial because the jury's mind had, by that stage, been irretrievably poisoned by it.
Well, yes, and they took the risk that the Court of Appeal might say that in circumstances where it was made clear that the documents are not being admitted at this stage, they're going to be admitted during the course of the trial. They needed to be admitted during the course of the trial in a formal fashion, and not just slipped in.
But these are the 2 points you're trying. I mean, you've got 2 horses you're trying to run here. One is absolutely no jury should be shown documents in opening.
Yes.
That's number one. We've had a lot of debate about that. The second is the documents have to be properly and formally admitted into evidence by a process during a trial. And I understand the argument that if, for example, you open the case to the jury and show them a document, even if it's not objected to, when the witness comes to be shown the document and they say, oh, that's not my document, I don't know, I've never seen it before in my life, Gov, that then the judge would have to figure out how to deal with that. Usually, he would just simply say it should be removed from the jury bundle, and the jury will be directed
To forget it.
to forget it and disregard it. And in fact, they won't be allowed to retain it. You know, that happens quite regularly in criminal trials. But that is not to say either they shouldn't be shown it at all at the election of the defendant at the start, or that it's necessarily a mistrial if what I've just described takes place.
Yes. Well, my lord, the 2 points are completely separate, and it's, well, not completely, but they're separate points, and I don't need... My defence of the Court of Appeal's fairly absolutist view on what the jury can be shown in opening doesn't have to be right in order for me to be right about the implications of this trial.
In the short time you've got for the second point, the Court of Appeal seemed to have taken the view that actually no process of admitting documents into evidence thereafter took place at all. Now, we've been shown by Mr. Jury some examples of some documents which, on the face of it, appear to have been admitted into evidence in the sense that the provenance of the document was affirmed by the witness. How do you... So on that footing, subject to what I hope you're about to say, it doesn't look as if the Court of Appeal's rather sort of monolithic approach to that second question was right. Some documents were properly admitted into evidence. And Mr. Jory says these are only examples. They all were.
Well, what the Court of Appeal must have meant is not that at no stage did anybody tell the court anything about the provenance of documents. It is that the process, the formal process, marking, formally admitting, does anyone object? No, in it goes. That process did not take place, and that much is common ground, I think. What I respectfully submit is the standard process, and I'm not giving evidence about that or inviting your lordships to necessarily think about other cases that you might have seen or presided over or heard appeals in relation to. But the Court of Appeal itself says this is the process. And
where does the Court of Appeal say that the process is that you have to formally stop at every stage that a separate document, each document of the 600, is put to witness? And I mean, as I understand it...
Well, I'm getting that from para 67, my lord, 1136. It is trite law that all documents, photographs, etc., satisfy the requirements of law to be admitted. During a trial, each piece of evidence should be marked and formally admitted. Such exhibits must be marked and formally admitted into evidence before they can be considered by the judge and jury. That, my lord, I respectfully submit, is squarely within the territory of what the Court of Appeal was entitled to say. They are entitled to say, in my submission, as the Supreme Court in relation to matters of procedure, that in the Eastern Caribbean, it is to be done in this formal way. And so in circumstances where in the present case it was accepted all round that, whether I'm right or wrong about the jury being shown stuff in opening, it was accepted all round that the only reason they were shown them was for the benefit of the prosecution opening its case, but questions of whether the documents were going to be admitted came later. In those circumstances, the Court of Appeal was entitled to say no document was formally admitted into evidence.
So that becomes your submission.
That's my yes.
None of this evidence was formally admitted.
That's what the Court of Appeal said, and in my submission they were entitled to say that, and indeed on their ruling that this formal process had to be followed, they were right to say that, because it's a common ground that no such formal process was followed.
And how does that match paragraph 69? It is the practice that each exhibit must be identified by a label or other mark and sufficiently described in the statement to identify it. Identification should be by the initials of the person who will produce the exhibit and a consecutive number. Are they talking about the same process, or are they talking about a prior process which will satisfy the requirements of identifying the document?
I think they're talking about the same process which one sees where it's done formally. So when one gets to it.
Why?
John Smith is giving evidence and may this be admitted. Yes, marked JS1.
But in Montserrat, I assume, as in the UK, there is pre-trial disclosure of documents, pre-trial disclosure of statements with exhibits to the statements. I mean, that's what we've just seen, haven't we, with the OMR 1?
Yes, but that's not that. None of that is evidence in the trial.
No, but it's sufficient to identify the document. I mean, what's...
Oh yeah, the objection is not to...
So what's your objection? Is it that during the trial, a clerk of the court didn't laboriously re-number and re-identify every page that was referred to as each witness referred to it?
No, my lord. The objection is that there was not, at each time a document was sought to be put into evidence, there was not a distinct focusing of the mind of the judge and of counsel as to whether this document should go into evidence. So there wasn't what I would describe as the standard process of counsel saying, may this document be admitted into evidence, and the judge saying to opposing counsel, any objection.
So that every time, for every page of the 600-page bundle in this fraud trial or any other fraud trial, every time a witness is asked to look at a page, the process has to stop for counsel to say, Your Honour, please may page whatever in this bundle be separately marked by the court clerk as Exhibit X. And any objection, no, okay, we'll wait and we'll do that. And then the next page,
well,
I mean, that has to get, you're saying that has to go on page by page by page.
That is the traditional way to do it, according to the judgment of the Court of Appeal, and they were entitled to say that's how it should be done. Obviously, in practice, if the only objection that were being taken were to some slight shortcut that had been taken in terms of the numbering. For example, if the court had said, well, this is already, on the basis of the written statements, this is already OMR 26, so let's not bother renumbering it, even though it's the fourth exhibit that's been spoken to, let's not bother renumbering it OMR 4 or trial OMR 4, let's keep it as OMR 26. That's just mechanics. The critical point is that there needs to be a moment at which documents, unless in advance the defendant has accepted that this document is going to go in and it's as it were akin to an agreed document in a civil trial, then there has to be a moment, so the Court of Appeals say, and I say there say this, at which the document is formally admitted, and that focuses minds. And my time's almost up, I think, but I did just want to illustrate.
So it's a formal admission.
Yes.
Point. It's the fact that your opponent says, well, in reality, they were asked about is this your document, etc. But yeah, the actual precise formality that one sometimes would insist on was not present. That becomes your submission, really, does it? It's informal rather than formal. It was informal rather than formal,
and that it wasn't always an entirely benign thing. And this is the illustration I just want to take the court to. If one looks at page 225, my lord, as I was saying, this was in the evidence of Mr. Allen, QC, who, in fact, was called as a witness of fact by the prosecution because he hadn't been involved in dealing with one of the properties. But you might recall the defendant, spotting that he was a retired thought and was wrongly by the judge allowed to get away with asking him some questions about the law. And my learned friend, we respectfully submit, ought not to have responded in kind, but did so. And we see that on this page 225, which is the re-examination of Mr. Allen. And line 12, it's been put to you in terms of legalities. If there were documents indicating another shareholder had first call on the shares and say they hadn't been notified of this agreement, of course that would have an effect, wouldn't it? Of course. And did you know, in fact, this transfer was challenged and subsequently declared null and void by a court? No, I did not know that. Page 248, you see this transfer was declared null and void. And then he goes on about asking some questions about whether it was a criminal or civil wrong. But the point is that document, that's the first time. If your lordships recall, the opening finished on the basis that no document had been admitted into evidence yet, and that would be a matter to be dealt with during the trial. The first time the jury has shown this American document is during the cross-examination of Mr. Allen, when the course of events continues really as it might in a civil trial where there's an agreed bundle. So there's no question of admissibility, or is this document...
Cross-examination or re-examination?
Forgive me, re-examination, arising from the cross-examination,
Yeah.
but in re-examination. Yeah. So there's no attempt there to lay any foundation or say, what is this document? Now, it's true to say that later on that document is referred to in the non-formal, but in the non-formal way that other documents were referred to in the evidence of Mr. Rooney. I think you see that at page 279, where my own friend asks about that. And I think my time has...
I've given you the extra 5 minutes because we started late. We really are coming up against this.
I have, yeah, and I don't think I can count on...
And have a great deal more business.
World Cup style stoppage time being added on either. So I think essentially I've said what I want to say about that on both of the two. No, I'm reminded to reiterate. We do take our stance on para 67 of the Court of Appeal. That was there. That's their point about the process. It should be followed, and in my submission, they were entitled to say that. Your Lordship, I'm sure, have the point.
We've heard that loud and clear. Thank you very much, Mr. Rowe. Mr. Jor, I don't think we need to trouble you to reply on this part of the case. And I think that means that perhaps earlier than expected, we're back to the respondent on the second part of the case. So I'm afraid you only got a very short breather,
That's all right,
Mr. Rowe.
Hydration break, Mr. Rowe.
Yes.
Yes, quite. I don't want to encourage a competition to see how many references to the World Cup ones we can get in today. So I won't try to respond in kind. Very well. Well, perhaps that takes me rather to where we were, in any event, hoping to start. Because in our submission, interesting though this debate about the proper procedure for admitting documents is, it's all academic in our respectful submission, because the decision of the Court of Appeal can be upheld and should be upheld on the rather more fundamental grounds that we identify in our case, which go, in fact, to the question of whether the indictment was good in law, whether there was a case to answer, and whether the trial was conducted fairly and the summing up was fair by the learned judge. The starting point ought to be, when it comes to the question of the indictment, and that's where I'll start, whether the indictment was bad in its face because it didn't identify any indictable offence of which the money constitutes the proceeds. The starting point ought to be, we submit, not case law, especially not case law about the various different provisions on the proceeds of crime that there have been over the years, but the starting point ought to be the Act itself and Section 33, which the Board can find at 2092. Section 33, a person commits an offence if he, A, conceals or disguises any property which is in whole or in part directly or indirectly represents his proceeds of criminal conduct, or B, converts or transfers that property or removes it from the jurisdiction. B wasn't deployed in the indictment, so it's entirely A that we're concerned with. And that act has got to be, as we see after the subparagraph B, going back into the main body of the subsection, for the purpose of avoiding prosecution for an offence to which this act applies, or of avoiding the making of or enforcement of a confiscation order. So one sees from that it's a section, and this may be why it's subsequently been repealed and replaced with something a bit broader, but it's a section that requires proof of quite a number of distinct elements. Concealing or disguising property which is, or in whole or in part, directly or indirectly represents his proceeds of criminal conduct for the purpose of avoiding prosecution for an offence to which the Act applies. Criminal conduct is defined in Section 2. We can see that on page 2059. Any conduct which constitutes an offence to which this Act applies, or would constitute such an offence if it occurred in Montserrat. So that, in the usual way of chasing these things down that lawyers have to get used to, requires us to go off somewhere else to find out what are the acts to which this, what are the offences to which this act applies, and that question is answered in section 3, subsection 2, references in this act, that's on page 2061. References in this act to an offence to which this act applies are references to all indictable offences except drug trafficking offences.
Sorry, on which page is that?
That's 2061.
Thank you.
So boiling all that down, it means, in our submission, that the prosecution had to prove to the criminal standard that the respondent, the defendant in other words, had concealed or disguised property that property was his proceeds of an indictable offence other than a drug trafficking offence, and his purpose in concealing or disguising that property was that of avoiding prosecution for an indictable offence other than a drug trafficking offence, or avoiding the making or enforcement of a confiscation order. And that's what required to be shown. There's not much case law about this precise provision, but we've cited in our written case, I can take it, I think, probably just from there, if I may, at paragraph 6, which is 1094 in the bundle.
1094.
1094.
Thank you.
Which is the Sabawal case in the Court of Appeal in England and Wales. That was a prosecution under Section 50 of the Drug Trafficking Act 1994, which is one of the predecessors of this regime. We've set it all out rather laboriously in footnote 1 of our case, where it all comes from. But Section 50 of the Drug Trafficking Act created the offence of assisting another person to retain the benefit of drug trafficking. And it was admitted in that case that the money in question was the proceeds of drug trafficking. And the submission was made, yes, but you can't actually point to the specific offence of drug trafficking that took place of which these are the proceeds. And the answer was you don't need to. It's sufficient to establish that it does come from that. You don't need to prove the particular instance. It's sufficient to say that it comes from drug trafficking. And then the other case which we refer, which I can also hope take from our printed case, paragraph 7, is the Anwar case. That was a case under the UK 2002 Act, which is the newer Act, so it doesn't contain entirely the same definitions, but that has a definition of criminal conduct which is broader because it's not limited to offences other than drug trafficking. The problem was the former regime, it started with drug trafficking, and then it was extended to other regimes, but you ended up with two different regimes, one for drug trafficking offences and another for non-drug trafficking offences, and you ended up with problems in these cases where you couldn't be sure whether the money was the proceeds of drug trafficking or some other criminal offence. But by the time Anwar comes along, they're dealing with the 2002 Act, where criminal conduct simply means the commission of any offence. And what the Court of Appeal said there, as we set out in our case, is that the Crown can prove the property derives from crime, A, by showing that it derives from conduct of a specific kind or kinds, and that conduct of that kind or those kinds is unlawful, or B, by evidence of the circumstances in which the property is handled, which are such as to give rise to the irresistible inference that it can only be derived from crime. So, to take an obvious example, if you find £1 million worth of banknotes which are heavily contaminated with cocaine under somebody's floorboards, and they have no obvious means of support, then you can probably infer that that's the proceeds of crime. You don't need to prove the particular instance of drug trafficking from which that relates. But the consequence of this in our submission is that, as far as going back to what's required to be proved by under Section 33 in the Act that we're concerned with, as far as that is concerned, the way in which you can establish that the money which you are, or property which you're referring to, and which you're alleging has been concealed or disguised, that's a different requirement which I'll come back to, but the way in which you can establish that property represents his proceeds of criminal conduct is to show either that it derives from, well, to show, as we've set it out in our case, really it requires, if you're going under lim A, which is about conduct of a specific kind, you've got to show that it derives from conduct of a specific kind by the defendant, and that conduct of that kind is constitutes an indictable but non-drug trafficking offence. In a sense, that's simply spelling out what the plain wording of the Act requires. So it follows from that the indictment has got to allege, and allege clearly so that the defendant understands what's being alleged, that as far as the property is concerned, it is the proceeds of the defendant's criminal conduct. And that requires the allegation of what the criminal, in our submission, of either of what the criminal conduct was, in other words, which offence, which indictable non-drug trafficking offence was it, or that it was, or that it was the proceeds of an indictable non-drug trafficking offence, even if we can't say which one, but you've got to be sure that it was at least one of them. But it can't be anything vaguer than that. It can't simply be that it was the proceeds of general wrongdoing. And that's the fundamental problem in the present case, because the...
Well, it can't be general, quotes, wrongdoing, which is obviously too vague, but you can say it has to be identifiable criminal conduct.
Yes.
Even if you can't spell out the individual criminal offence. But if you can say the only way that he could have this is by having committed a criminal offence, I don't have to tell you exactly which one. Or
yes, but the complication with simply applying, that's really that's the Anwar statement, and that's right. But the complication with applying that to the present case is that we're dealing, unlike Anwar, where the Act that was being applied there defined criminal conduct as encompassing the commission of any offence. In this case, criminal conduct doesn't mean any offence. It means an indictable offence other than drug trafficking. So you've got to make the jury sure this is the defendant's proceeds of an indictable offence other than drug trafficking. It's not good enough just to say it's the proceeds of criminal conduct. If we look at the indictment in the present case that's on page 138, for example, we can see that the way it's done is, in our submission, not adequate. So the particulars of the offence are that he transferred, it's plainly charged under section 31(1)(a), so we're only dealing with concealing or disguising, the $855,380 carry-in dollars odd transferred from investors into the bank account of Cassell & Lewis for the sale of land at Providence Estate, which was in whole or in part, directly or indirectly, the proceeds of criminal conduct, namely, and this is where the indictment needs to spell out which offence or offences, indictable and not drug trafficking, are alleged. But instead of that, what it does...
But are you saying it actually needs to say was, in whole or in part, the proceeds of criminal conduct, namely a breach of section whatever, or obtaining property by deception contrary to such and such a statute? Are you saying it has to say it to that level of particularity, or could you just identify some activity which, properly analysed, is a criminal offence? I'm sorry, Matt?
An indictable criminal offence.
An indictable criminal offence, which is not drug trafficking. Yeah.
Yeah, sorry.
Yes. I think I answered that question in stages. The way it ought to be done under this, or ought to have been done, it's all academic now because this has all been repealed and replaced with a regime which is modelled on the modern English regime. So it's academic. We're only dealing with this because this case is so old and it's taken such a long time to work its way through the system twice. But the proper way to do it is I would submit, the former, to say in terms, so that the defendant knows clearly what's being alleged in terms of criminal conduct, namely the commission by the defendant of the offence of ... And it could be the commission by the offence by the defendant of the offence of ... or of X or Y or Z, in principle, because you don't have to identify the specific. You just have to make the jury sure that it's the proceeds of the commission of an indictable non-drug trafficking offence.
But if the way you've described it inevitably includes
That would be
indictable
my
offence,
Yes, I think I would have to accept that that although that's what should be done, if the conduct you describe, if it happened, inevitably meant that the money was the proceeds of the commission by the defendant of an indictable non-drug trafficking offence, then I think I would be struggling to say the mere failure to spell out the relevant statute under which the offence occurred.
so this is a substance and form type dispute.
Well, that would be a substantive form dispute. But of course, if one applies so my primary point is that it's defective because it doesn't spell out the offence. But whether I'm right or wrong about that, the important substantive point is it's got to spell out something which is an indictable non-drug trafficking offence. And this indictment doesn't do so, because it goes on to, as your lordships have seen, it goes on to say, namely, the fraudulent conduct of Warren Cassell. And our first point about that is there is no offence of fraudulent conduct in the law of Montserrat.
No, the real question is whether it's an indictable offence to dishonestly make the representations pleaded in 1 and 2.
Yes, or
filing the charge and
importantly,
receiving the money into the bank account.
Importantly, to dishonesty to make the representations or any of them, because the way it's been drafted, and this wasn't inadvertent, because many times during the course of the case the jury were expressly told these are disjunctive. The way it's been drafted is such that one needs to read and or as potentially encompassing or. That's the point of and or. So it's got to work. If the allegation is that his criminal conduct, that is to say his indictable non-drug trafficking offence, which he committed, which gave him these proceeds, was representing that he was a legitimate director of Providence Estate Ltd, or representing he was entitled to sell land, or filing a change of directors application, etc., or receiving funds into the bank account. And the short point, my lords, is that none of those is an indictable non-drug trafficking offence. And there's been no, and we made that point. We made that point in our written case. The lordships might have noticed that although there was a statement of facts and issues which identified
you say none of those is?
None of these has been identified as an indictable non-drug trafficking offence. No.
If done dishonestly.
Even if done dishonestly.
Well, why isn't it? I mean, I'm not familiar with what the law was, but you would imagine that this was obtaining property by deception under the old English law before we went to fraud.
Well, my lord, the problem is that you can't say, his conduct generally was obtaining property by deception, because on the terms of this indictment, and the jury were repeatedly reminded of this, these are disjunctive. If any one of those is established, then that's enough for conviction, says the indictment, and said the prosecution in the course of the case. But so it's got to be an indictable non-drug trafficking offence to represent that you're a legitimate director of Providence Estate Ltd.
To dishonestly represent.
Dishonestly, I omit that, but that's important. Yes, dishonesty to represent.
I mean, all of these are caveated by dishonestly.
Yes.
Yes. But it's.
I mean, your short point is that if I dishonestly represent that I'm a legitimate director of Providence Estate Ltd, that's not an indictable offence.
No. It might be something that you did in the course of committing an indictable offence. I can see that, but that's not the way this indictment works. This indictment is premised on the proposition that if the jury accepts any one of those four as having happened and happened dishonestly, that completes the commission of the Proceeds of Crime Act offence.
So remind me again why you say that it's not good enough that any one of them. So if they said, yes, we are satisfied that the money was the proceeds of a dishonest filing of a change of directors, which, let's say, we assume is a criminal offence to make a false filing at the company's registry, if they were satisfied of that mechanism, that isn't good enough.
My Lord, a couple of answers to that. One, as a matter of fact, we did check this, albeit admittedly as rather an afterthought as we were preparing the case, and there is a summary offence of making an untrue representation on a form that you fill into the company's registry. But much more fundamentally than that, the reason, my Lord, is that juries don't give reasoned judgments. So in looking at, as your Lordship knows, in looking at this, one has to assume that a guilty verdict, one needs to work on the basis that a guilty verdict needs to be sustained on the basis of any of those four having been established. We don't know.
Yeah, no,
Even if it were right, even if suppose that paragraph 1, instead of saying representing, paragraph 1 gave a perfect textbook description of the commission of an indictable non-drug trafficking offence, giving all the particulars of everything.
Yeah.
The fact is, it's undermined by the or and all the others. All four of them have got to be indictable non-drug.
But that's because you say it's possible the jury may have come to the view that the defendant was guilty on something which didn't fulfil the requirements.
Yes. Yeah.
And the illustration you've just given, namely that dishonestly filing a change of directors is, for example, only a summary offence, not an indictable offence.
Yes.
So you don't have an objection per se to the and or formulation. You just say it doesn't work if one of the alternatives doesn't fulfil.
Yes, I don't complain about. I mean, it's up to the prosecution. I
was just playing catch up. Sorry.
Put shortly, and or is fine, so long as all four are indictable offences, and it's no good if only 3 are.
Exactly. Well, that's precisely the point. And in our submission, there's really no answer to that. And as I was saying, we settled this out
just before you leave that, is it the fact that the representation itself might not be, but if it's linked to the obtaining of property dishonestly, why wouldn't that then be the indictable offence? Because they're talking about effectively proceeds of criminal conduct. So in a sense, you might say, well, that's the obtaining of the property, and you've done it by deception and dishonestly on any of these representations. The first 3 are all, in effect, representations, aren't they, all equivalent to?
The first 3 representations, the last one isn't in fact a representation at all.
No.
I mean, it is. I mean, it's a problem with the drafting of this act, which is no doubt why it was redone. That effectively the prosecution do have to prove the commission of an offence by the respondent. So in a sense, you might say, well, why bother with this? Why don't they just prosecute him for the offence? And indeed, that in a sense, that's what we would say.
My point is, of course, just representing that you are a director and you're not is not an indictable offence. But if you represent that and obtain property as a result of it, that would be an indictable offence.
It might well be, my lord, but that's not what the indictment says. The indictment spells out what the criminal conduct is.
You see,
it stakes everything on each of these 4 constituting indictable non-drug trafficking offences, and they don't.
So the fact that there's no obtaining of property by any of these would rule out my argument.
Well, what rules out the argument, my lord, is that if I'm right about what criminal conduct needs to be, which I say I am because that's what the Act says it is, then this indictment, which spells out what the criminal conduct is, needs to, because of these being disjunctive, it needs to assert in each 4 something which is by itself an indictable non-drug.
It's the disjunct.
Yeah. Okay.
I think what you're saying, as I understand it, is that although if it had said and, it might have necessarily amounted to the offence of obtaining property by deception, because it would have the element of dishonesty, a dishonest representation, and the receipt of funds.
Yeah.
You're saying, because it says or, and it's the disjunctive, you can't be sure of that, because undoubtedly, if it was and, if you could be sure the jury would be satisfied of, let's say, 1 and 4, i.e. there was a dishonest representation which led to a receipt of funds, then you'd be hard pushed to say that isn't obtaining property by deception.
Well, I wouldn't concede that point, my lord, because if that were the case against us, I'd want to go away and look pretty closely at what arguments I could run in relation to the precise requirements of obtaining property by deception. But I take your point. But my point is we never get there because of the or. Your lordship's got that point, I think, very clearly. So, my lord, that by itself is a sufficient reason, but there are more problems with this indictment than that, and this comes to our second point, which we deal with in our case at 1097 onwards. It didn't give particulars as to how the respondent was alleged to have concealed or disguised the money. And we point out in our case that the Criminal Procedure Code requires the giving of such particulars as may be necessary for giving reasonable information as to the nature of the offence alleged, and the acts or omissions alleged to have given rise to the offence. And in Montserrat, that's underscored by the Constitution, which requires everyone charged with a criminal offence to be informed in detail of the nature and cause of the accusation against him or her. So what was it that constituted the concealing or disguising of the 850,000 odd Eastern Caribbean dollars? The indictment is completely silent on that question. So we're told nothing in the indictment about how they were concealed. One can think of obvious examples of cases where money is concealed. Cash can be concealed like any other object can be concealed, and there are cases in the books about people who find difficulty explaining why they've got £1 million under the floorboards when the police come round with a warrant. We're not in that territory. This was money that was paid pursuant to what were on the face of them standard conveyancing transactions into a bank account of a company which bore the name Cassell and Lewis. There wasn't much concealing going on there, and neither was there any disguising in our respectful submission. These transfers were made in the process of what were apparently open sales of property. So that alone in our submission just leaves matters completely unsatisfactory on the indictment, and it's an indictment which is bad in law for failure to state any particulars of that element of the offence. But the whole case seems to have proceeded on the basis, and indeed I'll show your lordships later, that the judge seems to have thought that the mere act of transferring the money ticked the necessary box for concealing or disguising. Yeah. But in fact, as we saw earlier, there's actually a separate offence of transferring, and he wasn't charged under that section.
Had he been charged under that, you would have had more difficulty with this objection, as I understand.
I think I'd repeat my answer to Lord Snowden's point earlier. I wouldn't necessarily concede it, but I can see that I'd be having to think of different arguments to raise. Certainly. Yes, but I agree that no one. The evidence was pretty plain that the money was indeed transferred, which was the proceeds of sale of these properties, purportedly by Providence Estate Ltd, though in fact by the defendant, albeit he did so in circumstances where he had obtained 60% shares in the property, subject to the rather important caveat that there was a right of preemption, which hadn't been complied with. So that's really a very short point on that, but there's no answer to that. And again, just going back to the point, I think I've started making this point about 3 times, and each time there's been a more interesting point that's occurred to the board, and I've dealt with it. But it's simply in terms of the procedure on this appeal. The statement of facts and issues identifies all of these points quite clearly as issues between the parties. In the appellant's case, there is no mention of them at all, and it was we who took the initiative of saying perhaps the appellant ought to put in something in writing before the board to say what the appellant says in response to these points in our case. And your lordships see that in the supplemental submission that our learned friends have made. But there's really no answer to this in those supplemental submissions. Then we come on to the next point, which is about, so those are 2 points about the indictment, and if I'm right about either of those, that's the end of any challenge to the Court of Appeal's decision, so far as its outcome is concerned, at any rate.
How does the application of the proviso come into it?
In relation to the Court of Appeal's decision, I think my learned friend says, he didn't expand on this orally, but he said in his written case that they ought to have applied the proviso, even if, in other words, even if they were right, which I infer from my friend not being called on that your lordships think they might not have been, but even if the Court of Appeal were right about the documentary point, nevertheless, the proviso ought to have been applied. Well, this point knocks out any reliance on the proviso, because the point about the proviso is that even without the error, the jury would inevitably and rightly have convicted. And if I'm right about any of these points on the indictment and all the points I'm about to come on to about the evidence and the trial, then that can't be the case.
Why? Sorry. The question whether the jury would inevitably have convicted is an objective question. And if, let's suppose, that the conduct in 4 was an indictable offence, and looking at the matter, it's inevitable that the jury would have taken that view. Does it matter that there's a theoretical possibility that they thought the only true bill was the filing the change of directors?
If the indictment is bad in law on its face because it doesn't allege conduct which must constitute the crime which is alleged, if it happened, then there can be no question of the application of the proviso, my submission. If the indictment is bad in law, it's bad in law.
I think that's what I was driving at. I mean, is that right? You say is there authority of the proposition that you cannot apply a proviso if the indictment is bad in law?
Well, it must be. I mean,
Well, is there an authority? I mean,
yes. Not that I can fire back across the court on my feet, my lord. But that's not to say there isn't one. But the fundamental point about the proviso is that the appellate court needs to be sure that there would have been a conviction inevitably, even if the relevant error had not occurred.
I mean, you frequently apply that to misdirections.
Yes, and I'll come on to the several misdirections in this case, and indeed
But you're saying it can't be applied where
I'd say in principle it can't be applied. If you find that the structure, I mean, the structure of this case, as it happens, is that the appellant appealed on the defendant won on the documents point in front of the Court of Appeal, and the Crown has appealed against that. But in substance, this is what I'm dealing with now is equivalent to it's really in the sense we're in the similar position that we were in 10 years ago. It's my appeal against conviction.
I mean, isn't the answer in principle that it can't be applied, the proviso can't be applied? Because if we apply the test, can we be sure that a jury properly directed would inevitably have reached a guilty decision? We can't, because
If they've been properly directed,
they're on a wrong indictment.
Yes, if they've been properly directed, in fact, they probably would never have been impanelled at all if the point had been spotted at that stage.
Yeah, which is why I was wondering whether there must be somewhere along the line a clear authority.
I'm sure there must be, my lord.
If you've got a bad indictment, you can't apply the proviso.
Yes. Yes. Well, I said the test was would the jury inevitably and rightly have convicted. I think possibly the respectable Burroughs gets it more accurate by saying it's inevitable the jury properly directed would have, because if the jury had been properly directed, they'd have been directed that this indictment is bad in law, if we'd ever got to that stage, which we wouldn't have done. So those are the 2 points about the indictment. Then we come on to the question of whether there was a case to answer. That's 14.4.3 in the Statement of Facts and Issues. We deal with it at 1099 onwards. And indeed, it's really a similar point, because to the point I've made about the defects in the indictment, there wasn't any evidence from the prosecution that the money was the proceeds of criminal conduct within the meaning of the Act.
But this is just a way of repeating your first point. I mean,
I suppose in substance, well, I guess it is. I mean, it stands or falls with the first point, I think.
well, because if we were to say, let's assume we're against you on your first point, then I'm not sure what you've got here.
Well,
I mean, is this a point on the evidence?
Well, it is a point on the evidence because
Yeah, but are you saying that, for example, assume that the indictment is good against your first point, assume you're wrong on the second point as well, that it's being made clear what concealing or disguising means, that a judge faced with a no case to answer submission would have had to say, well, there is no evidence that from which a jury could safely conclude
yes,
that indictment is made good. I'm just struggling.
Your Lordship must with respect be right about that. If the board concludes that this was a good indictment in the sense that establishing any one of the four things would have been sufficient, then I think I accept, inevitably I accept that there was evidence of at least one of those four things. There was evidence of receiving the funds into the bank account, for example.
There was evidence from which the jury could have concluded that these statements were made dishonestly. They could.
They could have done. Yes, there was evidence.
And therefore, it should have gone.
Done.
So it could have. So the judge would have been failing to not leave it to the jury.
Yes, he would have. Yes, he would have had to direct them properly, but that's a later point. But your Lordship's with respect right about that. Similarly, well, it's not quite the same perhaps, but in relation to concealing or disguising. Again, this is a short point, but was there any evidence that on the basis of which the jury could have concluded that concealing or disguising took place here? And this is, I think, different from the point we've just discussed, because even if your Lordships conclude that it's good enough for the indictment simply to assert concealing or disguising without giving any particulars, which is what this indictment does, and for the reasons I've given the board, we would submit would be wrong to say that, but just suppose that you don't agree and you say it's enough just to assert in the indictment that he concealed or disguised without explaining anything about how there was concealment or disguisement. Where was the evidence of concealing or disguising? We submit there was no evidence of that at all. The evidence was simply, as I've already said in the course of talking about the indictment point, the evidence was simply that there were these transactions with Mr. Cassell saying that he was entitled to act on behalf of Providence Estate Ltd, and people paid the money into the Cassell and Lewis bank account. But that doesn't show that he concealed or disguised the money. Indeed, we've made the point in our Britain case, and I don't want to belabor it now, but that he acted throughout this case with really no attempt at being in any way clandestine.
Concealing or disguising carries its own mens rea requirement, presumably quite separate from the purpose of avoiding prosecution, or doesn't it?
Well, it's got to be intentional conduct.
Yes, intentional concealing. Well, is it just intentional conduct, i.e. paying into a bank account, or is it intentionally to conceal? Because there's a separate purpose, which is for the purpose of avoiding prosecution. That, to my mind, is obviously subjective, but I'm just looking at the earlier bit, concealed or disguised.
Yes. Well, the Act doesn't say dishonestly conceal or disguise.
No.
So I suppose that there's no element of dishonesty in that sense of mens rea, but there is. It's got to be. It's simply got to be intentional conduct. But it's hard to see how you can have an intentionally concealing or disguising, at least in this context, without there being some element of dishonesty. But the critical point from purposes...
It's not enough one concludes that paying it into a bank account had the effect of concealing it. It's got to be, that's what he was out to do.
Yes, it's got to be.
I'm just looking to see what it is that has to be proved that you say there's no evidence of.
Yes. Well, I would say my primary submission would be there is no evidence of concealing in any sense. And I suppose this picks up on what your Lordship asked me about what's the mental element of that. What do we mean by concealing? But concealing means hiding, doesn't it? It means trying to prevent somebody else from being able to see it. There's other ways of saying the same thing. And if it needs to be in that sense intentional concealing, there certainly wasn't any evidence. But nor, in fact, was there any evidence, even if one can inadvertently conceal something, which I suppose perhaps as a matter of language one can. He didn't do that either. nor for that matter did he disguise the money as anything else.
I mean, have I understood that the actus reus relied upon is actually paying the money into that bank account of Cassell and Lewis?
Yes.
As to which it happened. Well, there's plenty of evidence from which the jury could conclude that that happened.
Yes.
But your real point must, I think, be, yes, but not probative of any...
Yes, not
intent
probative of any concealing, or yes, or even of any concealing or disguising. No. I mean, it's fair to record, and we point this out in a footnote in our case, that there's a section 33 of subsection 3 of the Act said that concealing or references to concealing or disguising include references to concealing or disguising the property's nature, source, location, disposition, movement, or ownership, or any rights with respect to it.
Yes.
But in any event, we say none
But
of
it's still
that.
concealing or disguising.
None of that happened. It's got to be concealing or disguising, and
So I'm
none of that happened.
Just trying to get it in my head. I mean, the sort of classic concealing or disguising in relation to money obtained by deception, money laundering, for want of a better expression, would be if you paid the money into a bank account in the name of some other person or some fictitious person over which you had control.
Yes.
I mean, that's
That's right. Or false invoicing, for example. If I want to explain, in case anybody later on asks me why I got £1 million from such and such a person, I might produce a false invoice saying I've done £1 million worth of consultancy work, and that would be an example of
that would be concealing or disguising the source. Yours would be concealing or disguising the source, and mine would be concealing or disguising the location.
I suppose that's right. Yes, but yes,
or the ownership or whatever.
Yes.
By
yeah.
putting it into a bank account in a false name that you,
Yes.
in fact.
But here, what Mr. Cassell does is to set up a company called Cassell and Lewis, applies to the High Court to have Providence Estate Ltd restored to the register, and enters into a transaction with Mr. Wood for a share transfer of 60% of the shares in Cassell and Lewis, etc., etc. So none of it is remotely in the territory of concealing or disguising. The whole prosecution seems to have proceeded on the misunderstanding that it was enough simply to prove that the money was transferred into the account. So that's that point. If any of these points is good enough, then that's the end of the challenge to the Court of Appeal's decision, because they got to the right result. The next one is 14.4.5. His purpose, because his purpose had to be, the jury had to be sure also that his purpose was, and there had to be, the jury had to have evidence from which they could properly find that his purpose was that of avoiding prosecution for an indictable, brackets, non-drug trafficking offence, or avoiding the making or enforcement of a confiscation order.
Okay, but this again is put forward, isn't it, on the basis, let's assume at this stage, that you've lost on the previous grounds, so that the hypothesis is that there has been some concealing or there is some evidence of concealing or disguising.
Yes. And that what he concealed or disguised was the proceeds of crime.
Yes, all
of the other bits have to be
right.
ticked, yes. But they still have to get over the hurdle of showing that his purpose in doing that was avoiding prosecution for an offence, which in this context means an indictable non-drug trafficking offence, or avoiding the making or enforcement of a confiscation order. And this was dealt with by my learned friend at the trial in answer to the no case submission, page 621, bottom of that page. Did the defendant conceal or disguise property for the purpose of avoiding prosecution or the making or enforcement of confiscation order? And my learned friend and his colleagues then say there is no suggestion that there was a confiscation order, so the purpose of concealing or disguising the property would have to be to avoid prosecution. And then they go on in a discussion about purpose, and that doesn't have to be the only purpose or even the main purpose, and it's different from motive or intent. But they simply assert there is a clear inference that whatever else he wanted, the defendant wanted to avoid prosecution. That being so, there is no question that this was at least a purpose of doing what he did. My lords, the problem with that is that if you're going to assert there is a clear inference that something is the case, you've got to identify what it is that the inference is based upon. From what is it to be inferred? And no attempt was made at that stage to identify from what it is to be inferred that the purpose of putting the money into Cassell and Lewis Inc. was to avoid prosecution. And even though we've taken this point in our written case and invited our learned friends to give an answer to it in a response, no answer is given in that response either. There was simply no evidence in our respectful submission from which any reasonable jury, properly directed, could have reached the conclusion that they were sure that Mr. Cassell's purpose in paying money, having money paid into Cassell and Lewis Inc.'s bank account, was that of avoiding prosecution. There's no evidence at all that he thought he was going to be prosecuted or that there was any basis for thinking he'd be prosecuted. He was doing all of this entirely openly.
Well, there wouldn't have to be any evidence that he was going to be prosecuted or something like that. I mean,
well, I agree.
You can simply
that
say
would be an example of something.
You can simply say, "I'm going to hide something because I know that if I don't, I might be found out and I will be prosecuted." And the fact that there was no threatened prosecution at that stage can't be.
No, I agree. Putting it too high to say that when I refer to the absence of any prosecution, I'm just saying I'm referring to or any intended prosecution. I'm referring to the absence of something which would make our learned friend's case much stronger. But I agree, it doesn't depend on.
I mean, you could. I mean, because say, for example, somebody who has obtained property by deception puts it into a bank account in a false name or the name of one of his compliant friends.
Yes.
That of itself could be a fact from which you could infer
Yes, I agree.
that he wanted to avoid prosecution.
Yes, I mean it's fairly tightly wound up with the concealing or disguising.
I'm just wondering how much it adds to the previous.
That's what I'm trying to get at.
If it's shown that he concealed or disguised it, well, why? And if it's shown that it was the proceeds of an indictable offence, well, quid erat demonstrandum.
Well, I can see why.
Well, or rather, I think again, the judge would say, no, that's for the jury.
Oh, yes.
Because this is all about whether...
This is all about no case to answer, yes.
Yeah.
Yes, well, no, I can see that, but nevertheless, I think I'm entitled to say, given that the offence breaks it down into a series of steps, we have to look at each step and see whether it's made. But I agree that they're interrelated. So
I'm just saying,
it'd be rather harder for me if your lordships thought that everything else had been ticked and there was concealing or disguising. I agree. It'd be rather harder for me to say there was no evidence that his purpose was to avoid prosecution. But anyway, stepping back and looking at the real case that we have, what we see actually is that he puts it into Cassell and Lewis Inc.'s bank account, which is a pretty stupid way of trying to conceal the money. You might have thought, might at least have had the wit to call it something else, but he doesn't. He puts his own name on the title of the company. So that deals with the points that the second limb, as it were, of our substantive complaints about this case. So I've dealt with bad indictment.
You haven't
no case to answer.
I mean, you haven't just to pick up the point, because you took us obviously to what was said at page 621 under heading 3. But just picking up the point we've just made, I mean, if there was concealing or disguising, then you could infer purpose from that, all the other boxes having been ticked.
Yes.
I mean, you didn't take us to... Do you want to make any observations at this stage on what was said supported the inference of concealing or disguising?
Well, the problem is that nothing, as far as we can see, nothing was said. That the no case submission was really dealt with by the submission of this note. And nothing was, as I recall it from reading the transcript, said, but I'll be told wrong if I've misremembered something, but there was nothing said specifically about what it was, from what there was to be this inference, from what this inference was to be drawn, on what basis this inference was to be drawn. So the fundamental problem seems to have been that the case goes wrong in this respect, really, at the concealing or disguising stage, because there's no There's no real attempt to show that there was concealing or disguising going on here. It seems to have been assumed it was enough just to show the transfer.
Well, no, but that's what I'm just asking you to whether you want to say anything specifically about what was said to indicate be the evidence of concealing or disguising.
Oh, I see what you mean.
At page 621.
Oh, further up.
Further up the page, this is what was said, and
Yes.
it may well be you'd say, well, I'll deal with this in reply, but
No, I can deal with that. Transferring the money, he was treating it as his own. That isn't, in my submission, concealing or disguising it. He didn't consult Rooney as director regarding these transactions. Well, that's true, but again, that's not a particular of concealing or disguising the property, or either on its face, or if you include the statutory inclusions. Control over the account. Well, of course he did, because it was his account. He was at the least exercising rights of ownership over the funds, but the Act doesn't say that exercising a right of ownership over a fund constitutes concealing or disguising it. Concealing or disguising, if we look at the passage that's helpfully set out at the top, includes concealing or disguising its nature, source, location, disposition, or ownership of any rights with respect to it. Concealing or disguising its ownership or any rights with respect to it. Well, he wasn't doing that in my submission. And there is evidence of expenditure from the funds. Well, again, that doesn't. This is expenditure from a fund which is being held in a bank account opened in the name Cassell and Lewis by the company Cassell and Lewis.
See, I mean, your submission has to be that no jury properly directed could treat any of these matters as concealing or disguising.
Yes, there was. Yes, any jury. Yes. So, well, that I think, I hope deals with that aspect of things. I see the clock. I've got about 4 minutes before 1 o'clock. Perhaps I can make a brief start on my next point, or I can break down if your lordships prefer. I don't really mind.
By all means, do.
So the next one is then we're on to conduct of the case and whether the trial was conducted fairly. And the first point we take in this context is the repeated evidence about the property having been purportedly sold for an undervalue. As your lordships know, the background is, of course, that Mr. Rooney was the 40% shareholder in the company. Mr. Wood was the 60% shareholder. The defendant had taken, so he thought, or so at least so it appeared on the face of it, a transfer of the shares of Mr. Wood, and it was having done that he began conducting himself as if he were director. And so Mr. Rooney is there to give evidence about the factual information that he knows about in connection with all of that. And if we go to the transcript, we can see the section that I'm complaining about in relation to this point. Pick it up at page 266. Mr. Rooney is giving evidence about whether he had approved the sale to a Mr. and Mrs. Farrell of a parcel of the company's land. And he duly says that on line 8 on that page 266, he says he didn't know about it until March or so 2008, so sometime afterwards. And in our respectful submission, that was the end of the admissible evidence that Mr. Rooney could give about that subject. Had he known about the sale of the land at the time? No, he hadn't. But instead, the prosecution go on to say, and in terms of the document itself, just look at the cost, 105,000 Eastern Caribbean dollars. Any comment you would like to make on the amount that bit of land was sold for? And Mr. Rooney says, well, 2 observations. My respectful submission, my lord, is the judge ought to have jumped in immediately at that point. Because this was plainly an improper question. Indeed, it was telegraphed as an improper question by the way it was asked. Any comment you would like to make? He wasn't there to make comments. He was there to give evidence about things that he had seen and done. But rather than stopping it, the questioning carries on. He makes his two observations. He was selling it at this attractive pricing.
Sorry, can I just pause there for a second? I mean, is it necessarily improper to ask somebody what their view of the value of a piece of property is, if they're aware of the piece of property? I mean, if you'd have taken a run up to it and asked, you know, are you familiar with a piece of land? You know, why is the person not entitled to express a view, if it's their piece of land, for example, as to what it's worth?
Because that is the expression of an opinion by a witness, as to which ordinarily these things are dealt with by opinion evidence from people who are entitled, who have expertise to speak to it. In any event, in this case, it wasn't a relevant and probative fact, in my submission, what the price had been sold. But in fact, what we see, as I'll develop this perhaps after the short adjournment, but as we see, in fact, what he goes on to do is then to refer to the existence of stuff which wasn't in evidence, namely somebody else's report that apparently substantiates this contention that it was there and it was sold and undervalued.
Well, we'll come back to that at 2
Yes.
o'clock. Court's adjourned.